All right, let's jump right in. Looks like we're tackling South African labor law today, specifically all those fascinating bits about contracts and dismissals, and even collective bargaining. We've got a whole stack of your study guides and materials here, and wow, it's a lot to unpack. But don't worry, expert speaker and I are here to break it all down.
You bet. South African labor law, it's full of twists and turns, that's for sure. Definitely some things that can catch you off guard if you're not careful.
Oh yeah, I was already spotting some of those gotcha moments just glancing through the material. Like in Study Unit 2, this whole concept that there are already like ground rules for employees and employers, even before anyone signs a contract. It's like unspoken expectations baked right into the system, right?
Exactly. We call these common law duties, and they're kind of like the foundation of any employment relationship. The fascinating thing is, even if your contract doesn't spell them out, both sides are still bound by these principles.
Okay, so just thinking off the top of my head, I'm guessing things like showing up for work on time and actually doing your job, confidently, those would fall under an employee's common law duties.
Right on. And on the flip side, employers have their own common law duties too. Things like providing a safe working environment, paying your agreed upon salary, that sort of thing. It's all about establishing a baseline of fairness.
So it's like you've got this foundation of common law that creates this kind of level playing field, but then Study Unit 2 also talks about how specific labor laws can come in and like layer on top of those common law principles.
Absolutely. Think of it like this. You have your foundation of common law, but then specific laws, pieces of legislation come in and might impose additional duties or rights. And sometimes they even override something in a contract if it doesn't meet the legal minimum standard.
Oh, I see. So even if you agree to something in writing, the law might say, nope, that doesn't fly. We have a higher standard here.
Exactly. Like you can't agree to work for less than minimum wage, even if you sign a contract that says you will. The law sets a floor for those basic rights.
Makes total sense. Okay, so we've got this whole system of duties and rights, but let's face it, things don't always go smoothly in the workplace. And that's where this whole concept of dismissal comes in. But according to Study Unit 5, it's not as simple as just getting fired, right?
You're catching on quickly. Dismissal in South African labor law, it's way broader than just getting the boot. It covers a whole range of situations where the employment relationship ends, even if the employer doesn't specifically say, you're fired.
Okay, now you've got me intrigued. What are some of those less obvious types of dismissals?
Well, think about it this way. Let's say an employer refuses to grant an employee their legally entitled maternity leave. That would be considered a dismissal. Or imagine a company forces an employee to accept like much worse terms of employment after a business transfer. That could also be dismissal under South African law.
So it's not just about the words used, but the actual impact on the employment relationship.
Exactly. If the employer's actions force the employee out or basically change the whole nature of the agreement, it could be considered a dismissal, even if they don't explicitly say, you're fired.
That makes a lot of sense. And of course, the big question with any dismissal is whether it was fair or unfair. And that's where things get even more nuanced, right? Study Unit 6 talks about how South African law doesn't just have unfair dismissals. It also has this whole category of automatically unfair dismissals, which sound a lot more serious.
Oh yeah, automatically unfair dismissals, those are like the red lines you absolutely cannot cross as an employer. They are inherently unfair no matter how you slice it because they violate fundamental rights. And it doesn't even matter what the process was or what the employer intended.
Okay, so what kind of actions would land an employer in that hot water, that automatically unfair territory?
Well, imagine an employee gets dismissed because they participated in a protected strike, a strike that followed all the legal procedures. Or let's say they blew the whistle on some illegal activities happening within the company. Those are protected actions, and dismissing someone for doing those things is automatically unfair.
I can definitely see why those would be off limits. You can't punish someone for exercising their rights.
Exactly. It's about protecting employees who are standing up for what's right. Like we have the Protected Disclosures Act, which specifically aims to encourage whistleblowing by protecting employees who report wrongdoing, as long as they're acting in good faith, of course.
Makes sense. You don't want to protect someone who's just spreading rumors or trying to get someone in trouble for no reason. But okay, so we've got these automatically unfair dismissals, but then what about regular unfair dismissals? How do you even go about proving that something was unfair?
Well, here's where it gets interesting, and maybe a bit counterintuitive. When it comes to unfair dismissals, the ones that aren't automatically unfair, the burden of proof is actually on the employee.
Wait, really? That's surprising. Wouldn't it make more sense for the employer to have to prove they were justified?
It might seem that way, but that's not how the law works in this case. So if you're an employee and you believe you've been unfairly dismissed, you need to present evidence showing that the employer either messed up the procedure or that the reason for dismissal wasn't a valid one, or that it was discriminatory in some way.
Okay, so I'm starting to see how this could get a bit tricky. Is there a real-life example of how this burden of proof plays out?
There is. Let's look at the case of National Union of Leather Workers v. Bernard, Eno, and another. In this case, a company was being liquidated, which meant all the employment contracts were automatically terminated.
So the business was closing down. What recourse could the employees possibly have?
Well, the court actually considered this to be a dismissal, even though it was because of the liquidation, because it was ultimately the employer's decision to wind up the company that caused the employment to end.
So even though it wasn't atypical firing, the employees still had some legal ground to stand on because it was the employer's actions that led to them losing their jobs.
Exactly, and that's why these legal definitions are so important. They can have a big impact on how a situation is viewed in court. Now, speaking of things that can be a bit tricky to wrap your head around, let's talk about dismissal for incapacity.
Okay, so usually when I think of incapacity, I think of someone who can't do their job, like maybe because they're not performing well or they have some health issues.
You're on the right track, but as Study Unit 8 points out, incapacity isn't always that clear-cut. It can also include this thing called incompatibility.
Incompatibility. So you mean like personality clashes or not fitting in with the company culture? Wait, are you telling me you can be dismissed for being too good at your job?
Well, not exactly for being too good. It's more about whether your working style or personality is so disruptive that it negatively affects the workplace, even if you're technically good at your job.
Wow, that's a curveball I wasn't expecting. So it's not just about your skills, it's also about how you work with others and fit into the overall environment.
Exactly. But of course, there are limits. Employers can't just use incompatibility as an excuse to get rid of someone they don't like. They have to prove that the incompatibility is actually causing problems, and they have to follow a fair process, giving the employee chances to, adjust their behavior or whatever is causing the issue.
So there needs to be a real tangible impact, not just a personality clash. Are there any cases that show how this incompatibility thing plays out in real life?
There's a great one that highlights how important procedural fairness is in these cases. It's Gustalo v. Datacore Holdings, S8 Ltd Thai Corporate Copilif. In this case, a manager was dismissed for alleged incompatibility, but the court said, nope, that's not fair. Why? Because the employer hadn't provided the manager with enough staff support. They basically set them up to fail.
So it's like they were blaming the manager for problems that were actually caused by the employer's own actions.
Exactly. The court saw right through that and said the dismissal was unfair. It just goes to show, even with something as subjective as incompatibility, employers still need to act fairly and reasonably.
All right, let's switch gears a bit and talk about dismissals based on operational requirements, which Study Unit 9 describes as being all about the needs of the business.
Right. So operational requirements dismissals, you might hear them called retrenchments sometimes. They're all about the employer needing to let go of employees because of how the business is running.
So like downsizing during tough economic times or restructuring to become more efficient, those would all fall under that umbrella.
You got it. But here's a twist. Did you know that sometimes an employer can dismiss someone because a third party demands it?
Hold on. What? How does that even work? Why would a third party have that kind of influence?
It might sound strange, but there are situations where pressure from a third party can actually be a legitimate reason for dismissal. Imagine a situation where a major client says, hey, we're not signing this huge contract unless you get rid of this particular employee. The employer might be able to justify a dismissal in that case, but only after jumping through a lot of hoops.
Yeah, it makes sense that there would be safeguards in place to prevent companies from just using this as an excuse to get rid of anyone they don't like.
For sure. The employer would have to prove the third party's demand is reasonable, that it directly impacts the business, and that they've considered every other possible option before resorting to dismissal. It's a tricky balance between the employer's needs and protecting employees from unfair treatment.
Speaking of balancing interests, it's interesting to see how the courts have changed their views on retrenchments over time. Study Unit 9 mentions that early on, a good faith, business-like approach was often enough to justify letting people go. It sounds like the courts were pretty hands-off back then.
That's true, but things have definitely shifted. Later cases, like National Union of Metal Workers of SAV Atlantis Diesel Engines, Ltd., established a much stricter standard. Now the courts are much more focused on whether dismissal was truly a last resort.
So it's not enough for a company to just say, well, times are tough, so we have to let people go. They need to show they've really explored all other options.
Exactly. Things like cutting executive salaries, reducing non-essential expenses, offering voluntary retrenchment packages, maybe even looking at ways to retrain employees for different roles within the company. Dismissal should only be considered when everything else has been exhausted.
It's amazing to see how labor law adapts to changing circumstances. Okay, so we've talked about dismissals based on misconduct, incapacity, and operational requirements. But Study Unit 11 brings up another whole dimension. unfair labor practices when it comes to promotions. I think we've all felt that sting of being passed over for a promotion at some point.
Oh, absolutely. That feeling of being overlooked or like the process wasn't fair, it can be incredibly frustrating.
Well, good news. In South Africa, there are laws to protect you from unfair practices when it comes to climbing the career ladder. Section 186 of the LRA, it spelled out exactly what constitutes an unfair labor practice related to promotion.
That's right. That section is all about ensuring that promotions are handled fairly and transparently. We're talking about everything from using biased selection criteria to completely ignoring established procedures.
So, like, if a company claims they promote based on performance, but then they consistently overlook high-performing women in favor of men with weaker track records, that could be considered an unfair labor practice.
Absolutely. Or let's say there's a policy of always posting job openings internally before considering outside candidates. If they suddenly ignore that policy and hire someone from outside without giving internal employees a fair shot, that could also be deemed unfair.
It sounds like it's all about holding companies accountable to their own policies and making sure everyone has an equal opportunity.
Precisely. Transparency and consistency are key. But remember, just because you feel slighted doesn't automatically mean an unfair labor practice has occurred. You need strong evidence to back up your claim.
What kind of evidence would someone need to have?
Let's say you think you were unfairly passed over for a promotion because your manager just doesn't like you. You'd need more than just a gut feeling. You'd need concrete evidence, like emails or witness statements that show the decision was based on something other than your qualifications and performance.
And this brings us to a great example of how this burden of proof plays out in real life. Mashabavi University of Johannesburg and others.
Oh, that's a good one. This case shows that courts aren't eager to overturn an employer's promotion decision just because an employee feels slighted. The employee really needs to come with strong evidence to prove that something unfair went down.
So, moral of the story, document everything. Keep track of your accomplishments, performance reviews, any interactions about promotions. You never know when you might need that paper trail.
Couldn't agree more. Documentation is key. All right, we've covered a lot of ground on dismissals and promotions. Now, let's shift our focus to another critically important area of South African labor law: unfair discrimination.
Okay, so this is where the Employment Equity Act, or EEA, comes in, right? The one that's all about making sure everyone gets a fair shake in the workplace.
Exactly. The EEA is like the champion of equality in the workplace, aiming to eliminate unfair discrimination and level the playing field. It says straight up, you can't be treated differently at work based on things like race, gender, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, or birth. And get this, it even covers discrimination based on any other arbitrary ground.
Wow, that is a seriously long list. It's amazing to see how much the law protects against discrimination. But I'm curious, how does this actually play out in the real world? What are some real-life examples of what would be considered unfair discrimination?
Well, think about it this way. Imagine a woman is paid less than her male colleague for doing the exact same job simply because she's a woman. That's textbook unfair discrimination based on gender. Or let's say a company has a pattern of denying promotions to Black employees who are just as qualified, if not more qualified, than their white counterparts. That would be considered unfair discrimination based on race.
It's reassuring to know that the law is there to address these kinds of situations. So the EEA says you can't discriminate, but it doesn't just stop there, right? Doesn't it also put a responsibility on employers to actively promote equality?
That's right. It's not enough for employers to just passively avoid discriminating. They have to take proactive steps to create a workplace that is truly inclusive and offers equal opportunities for everyone.
Okay, so what does that active effort actually look like?
Well, it's about going beyond just treating everyone the same. Employers need to be proactive about addressing existing inequalities. A big part of that is something called reasonable accommodation.
Reasonable accommodation. What exactly does that mean?
It's a really important concept, especially when it comes to employees with disabilities. It means that employers have to make adjustments to the workplace or even to the job itself to accommodate the needs of employees with disabilities. This could mean providing things like assistive devices, modifying workspaces, or adjusting work schedules to make things work for everyone.
So it's about creating a workplace where everyone has a fair chance to succeed, regardless of their differences. I love that. It really shows a commitment to genuine equality.
Exactly. Reasonable accommodation is all about recognizing that sometimes fairness means going the extra mile to make sure everyone has what they need to thrive.
Wow, this has been so insightful. We've covered a ton of ground in this first part of our deep dive into South African labor law, from the very basics of common law duties to the complexities of dismissals, the ins and outs of collective bargaining, and these key pieces of legislation like the EEA. I'm already feeling much more informed about my rights and options in the workplace.
That's great to hear, and this is just the beginning. We've got a lot more to unpack in the next part of our deep dive, so stay tuned. Welcome back, ready to dig even deeper into South African labor law.
Absolutely. We were just talking about equality, and now I'm really curious to learn more about this whole idea of freedom of association that Study Unit 14 talks about. It sounds like a pretty fundamental right for employees.
It is freedom of association. It's all about your right to join and participate in a trade union, without facing any kind of backlash for it. And it's protected by both the Constitution and the Labor Relations Act.
So basically, it means employees can band together, speak up about their concerns, and try to negotiate for better working conditions as a collective force.
Exactly. It's about giving employees a voice, a way to have a real say in their workplace. But, there are some rules and limitations around this. It's not a complete free-for-all.
Oh, what kind of limitations?
Well, when you join a union, you're agreeing to follow their constitution, their internal rules. And those rules can vary from union to union. However, there are some things a union's constitution can't do, like discriminate based on race or sex.
That makes sense. A union shouldn't be allowed to perpetuate the same inequalities it's supposed to be fighting against. Okay, so you've got this right to join a union, but what does that actually look like in practice? How does it translate into real change in the workplace?
That's where collective bargaining comes in. Study Unit 16 dives into this whole process where employers and trade unions sit down and negotiate terms and conditions of employment for employees. It's a way to address workplace issues in a more structured and formal way, with the goal of finding solutions that work for everyone involved.
So it's like a big group conversation instead of just one employee talking to their boss. You've got the entire workforce, represented by their union, having a dialogue with the employer about things that affect their jobs.
Exactly. And the result of those negotiations is often something called a collective agreement, which is basically a written agreement that covers all those key things we talk about: wages, working hours, leave, grievance procedures, that sort of thing.
So it's like a contract, but instead of just being between one employee and the employer, it covers the whole group of employees represented by the union.
You got it. And that's where the real power of collective action comes in. Employees can often achieve much more by working together than they ever could on their own. And here's another interesting layer. Collective bargaining, it doesn't always just happen at the company level. Sometimes it happens at the industry level, where a union representing workers in a specific industry negotiates with all the employers in that sector.
Wow. So you could have like a collective agreement that covers all the workers in the manufacturing industry, setting standards for the whole sector, not just one company.
Exactly. It's all about creating a more level playing field across an entire industry. Now, let's be realistic. Even with the best intentions, sometimes negotiations just hit a wall. What happens when those talks break down and employers and employees can't seem to see eye to eye? Well, that's where things like strikes and lockouts come into play.
Ah, yes, the more dramatic side of labor relations. Study Unit 18 definitely piqued my interest with this one. Strikes and lockouts, those are pretty powerful tools, aren't they?
They are. They're the heavy hitters that both employees and employers can use when negotiations reach a stalemate. But of course, there are rules and regulations around how and when they can be used.
I was wondering about that. I mean, is the right to strike even mentioned in the South African Constitution? It seems like a pretty fundamental right.
It is. The right to strike, it's explicitly protected by the Constitution. However, the right to lock out employees, that's not specifically mentioned.
Oh, interesting. It seems like there's a bit of an imbalance there. Why is one protected while the other isn't?
Well, it comes down to the whole purpose and nature of these actions. The right to strike, it's seen as a crucial tool for employees to protect their interests, to try and balance the power a bit in the workplace. It's a way for them to say, hey, we're not happy and we're willing to withhold our labor to make a point.
So it's about giving employees a strong voice when they feel like they're not being heard.
Exactly, but that doesn't mean you can just strike whenever you feel like it. The Labor Relations Act sets out clear procedures for a strike to be protected. Like the dispute has to be about a matter of mutual interest, and there have to be attempts to resolve it through other means like conciliation before resorting in a strike.
So it's a last resort, not a first response.
Right, and while the right to lock out employees isn't explicitly in the Constitution, it is recognized as a legitimate tool for employers under the Labor Relations Act. But just like strikes, there are rules and procedures they have to follow.
So a lockout is basically the employer's version of a strike. They're temporarily shutting things down to try and put pressure on the employees.
That's it. And just like with strikes, employers can't just lock out employees on a whim. They have to follow the rules.
It's fascinating to see how all these different pieces fit together. It's like a complex dance between employers and employees with all these rules and strategies coming into play. But, it's not always about this adversarial back and forth struggle. There are also ways for employers and employees to work together more collaboratively. That's where workplace forums come in, right?
Absolutely. Workplace forums, as described in Study Unit 20, are all about cooperation, about finding common ground. It's a platform for employers and employees to sit down together, talk things out, and make joint decisions about things that affect the workplace.
So it's less about us versus them and more about finding solutions that benefit everyone.
Exactly. It's about moving away from that adversarial mindset and fostering a more collaborative approach.
So how do these workplace forums actually work? Who can set them up, and what kinds of things do they typically deal with?
Well, you can't just have a workplace forum in any company. The law says you need at least 100 employees to establish one. It's more common in bigger organizations where there's a greater need for that structured communication between management and employees.
Makes sense. And what kind of issues do these forums typically address?
Oh, it's a pretty broad range. They can weigh in on things like disciplinary codes and procedures, rules about how the workplace operates, health and safety issues, even retrenchment procedures. It's about giving employees a real say in decisions that affect their work lives.
It sounds like a really valuable way to empower employees and make them feel like they're part of the decision-making process.
It is. It's about creating that sense of shared responsibility and working together towards common goals. Now, let's face it, even with the best intentions, disputes are bound to happen in any workplace. And when they do, it's important to have a clear process for resolving them.
Okay, so Study Unit 21 is all about navigating those tricky waters when conflicts arise. What happens when an employee and employer just can't agree on something? How do you even begin to sort that out?
Well, South Africa has a well-defined system for dealing with workplace disputes, but the first step is figuring out what kind of dispute it is. We're talking about the difference between a dispute of right and a dispute of interest.
Okay, you're going to have to break that down for me. What's the difference between those two?
Think of it this way. A dispute of right, it's all about whether an existing right has been violated or misinterpreted. It's like arguing over whether a rule in the company handbook was applied correctly in a particular situation.
So, like, if an employee feels they were unfairly dismissed, that would be a dispute of right.
Exactly. Now, a dispute of interest, that's a bit different. These usually come up during collective bargaining, and it's about disagreements over creating new rights or changing existing ones, like arguing over what the new salary scales should be or how many days of annual leave employees should get.
Ah, okay, I see. So a dispute of right is about interpreting what's already there, while a dispute of interest is about negotiating something new or different.
You got it. And the reason this distinction is so important is because it determines which path you take to try and resolve the dispute.
Okay, so walk me through those paths. What are the options for resolving workplace disputes in South Africa?
Well, the first step is usually conciliation. It's a less formal process where a neutral third party, a conciliator, comes in and tries to help the two sides reach an agreement.
So it's like having a mediator try to find common ground and hammer out a compromise.
Exactly. But if conciliation doesn't work, then what happens next depends on the type of dispute we're dealing with. For disputes of right, the next step is usually arbitration.
And what does arbitration involve?
Arbitration, it's a bit more formal. You've got an arbitrator, another neutral third party, who listens to evidence from both sides and then makes a decision that everyone has to abide by. It's like a mini trial, but usually quicker and less expensive than going to court.
So the arbitrator acts like a judge, making a ruling based on the evidence presented.
That's right. Now, for disputes of interest, especially those stemming from collective bargaining, things can get a bit more complicated. There might be additional steps involved, like maybe even strikes or lockouts, as we discussed earlier. But ultimately, the goal is always to reach some kind of resolution, whether it's through negotiation, mediation, or arbitration.
And if all else fails, can you always take the dispute to court as a last resort?
You can. We have the Labor Court, which is the final authority for resolving labor disputes in South Africa. They can hear appeals from arbitration decisions and make rulings on complex legal questions. It's like the Supreme Court for labor law.
But it sounds like going to court is something you'd want to avoid if at all possible.
Definitely. It can be a long and expensive process, so it's usually best to try and resolve things through those earlier stages, like conciliation or arbitration, if you can.
This has been so eye-opening. I'm starting to realize just how much there is to know about South African labor law. It's such a complex and intricate system.
It is, but you're doing a great job of unpacking it all. We've covered so much ground already, from those basic employment contracts to the nuances of dismissals, the power of collective bargaining, and the different ways to resolve disputes.
All right, welcome back. We're wrapping up our deep dive into South African labor law, and I'm ready to get into the specifics. We've talked about these big concepts, but now I want to know how it all actually works in practice. What are the laws that really shape the day-to-day experience of working in South Africa?
You're thinking like a true legal eagle. We've got the framework. Now let's zoom in on some of the key legislation that brings those principles to life.
Perfect. So let's start with something that's probably on everyone's mind, getting paid. What are the laws around wages and working hours in South Africa?
Well, that's where the Basic Conditions of Employment Act, or BCEA, steps in. It's all about setting those minimum standards for things like working hours, overtime pay, rest periods, the essentials. It's like a safety net to make sure employees aren't being exploited.
Okay, so let's break it down. What exactly does the BCEA say about how much we're allowed to work each week? I'm all for a good work-life balance.
The BCEA sets the standard work week at 45 hours max, and if you're working a typical 5-day week, you can't clock in more than 9 hours a day. Of course, there are some exceptions for certain types of jobs, like if you're in senior management, where the demands and expectations might be different.
So that's the baseline, but what about overtime? Is there a limit on how much overtime your boss can ask you to work?
Well, the BCEA doesn't put a hard cap on overtime hours, but it does say that anything over that 45-hour week has to be paid at a higher rate, usually time and a half, so 1.5 times your regular hourly rate.
That makes sense. It's an incentive for employers to keep overtime to a minimum and to fairly compensate employees who are putting in those extra hours. Now, what about breaks during the day and time off on weekends? Surely there are laws about that too, right?
Absolutely. The BCA is all about protecting your well-being. Employers have to give you those daily rest periods, like a lunch break, and you're entitled to at least 36 consecutive hours off each week, which usually means the weekend. It's all about making sure you have time to recharge.
3 cheers for weekends. But what about those times when you get called in to work on a Sunday? Is that even allowed?
It is allowed, but it's not something employers can just demand without consequence. The BCEA says if you work on a Sunday, you have to be paid a premium rate, usually double your regular hourly rate. It's recognizing that Sundays are typically a day of rest, so you deserve to be compensated accordingly if you have to give that up.
Okay, so we've got the basics of working hours and pay covered, but what about vacation time? Everyone needs a holiday now and then.
For sure. The BCA lays out the minimum requirements for different types of leave: annual leave, sick leave, maternity leave, family responsibility leave, the works. It's about making sure employees have time to rest, recover, and take care of personal things.
Okay, let's start with the one we all love, annual leave. How much paid vacation are we entitled to in South Africa?
At least 21 consecutive days per year. That's 3 full weeks to relax and recharge.
3 weeks. Not bad at all. Now, what about when we get sick and can't come to work? Is there a right to paid sick leave?
Absolutely. The BCEA says you accrue paid sick leave as you work. For every 36 months you work, you build up sick leave equal to the number of days you would normally work over a 6-week period.
So if you work a standard 5-day week, you'd get 30 days of paid sick leave over those 3 years.
Exactly. No one wants to worry about losing income when they're not feeling well.
Absolutely. Now, let's talk about maternity leave. It's so important for new mothers to have adequate time off.
It is. Under the BCEA, women are entitled to at least 4 months of maternity leave.
4 months, that's fantastic. It gives them time to bond with their baby and recover. But is it paid leave?
That's where things get a bit tricky. Unfortunately, the BCEA only requires unpaid maternity leave. There's a big push to change that and make it paid. But for now, it's really up to each employer to decide whether they offer paid maternity leave as part of their benefits.
Fingers crossed that changes soon. It's a big gap in the system right now. What about leave for family responsibilities other than having a baby?
Well, for that, we have family responsibility leave. The BCEA says you get 3 days of paid family responsibility leave each year.
And what kind of situations does that cover?
Things like the birth of a child, the death of a close family member, spouse, parent, child, or if your child gets sick and you need to take time off to care for them, it's there to support employees during those major life events.
It's good to know those protections are in place. We've covered so much ground in this deep dive, from employment contracts and dismissals to collective bargaining and these specific laws like the BCEA. It's a complex area of law, but I have to say I feel much more informed now, like I have a much better understanding of my rights and how things work in South Africa.
That's what we like to hear. Knowledge is power, right? Understanding your rights and options is crucial for both employees and employers. But remember, this deep dive is just a starting point. If you're ever facing a specific issue or have a tricky situation, it's always best to chat with a legal professional.
Absolutely. There's no substitute for your personalized advice from an expert. Thank you so much for guiding us through this fascinating world of South African labor law. It's been a real eye-opener.
My pleasure. Always happy to share what I know.
Until next time, happy lawyering.